Hello and welcome to the last day revision lecture for the liquidation process of the corporate debtor pursuant to the resolution plan not being approved by NCLT or the failure to submit a resolution plan by the corporate debtors COC. So in that case, we have that if the maximum, so this is first question, which is again very important, that when will the liquidation be initiated by the adjudicating authority? So the liquidation will be initiated by the adjudicating authority if the resolution plan is not submitted to the corporate to the NCLT within that 180 days time period or 90-day time period or that overall 330 days time period. That is, if the resolution plan is not submitted by the expiry of the insolvency resolution period or the maximum time permitted for the completion of the corporate insolvency resolution process, then the application or the NCLT is going to order for the initiation of the liquidation. Then if the resolution plan is submitted but NCLT rejects the resolution plan, or in that case the the corporate debtor would be liquidated here. Now at the same time, if the resolution professional, okay, during the CRP process but before the confirmation of the resolution plan intimates to the adjudicating authority the decision of the COC that the approval of 66% of the voting share has been received and they are of the opinion that the corporate debtor should be liquidated, then NCLT will pass the liquidation order. So you can get this question: when will the liquidation order be passed by the NCLT? So it will be passed when the resolution plan is not received during 180 days time period or the maximum time period which was permitted for the completion of the CRP, or if the resolution plan is rejected by the NCLT, or if the members of the committee of creditor with a 66% voting share approves that the resolution process should be stopped and the corporate debtor must be liquidated. One more question which you get mostly, and this is for the old syllabus I'm telling you, mostly you're going to get this question that earlier the default was one of the route for the liquidation of the company, but now it is not. So now if the company's default, okay, if any company defaults in its payment, liquidation or winding up petition is no longer a ground. If now a company defaults, you will have to go through first with the CIRP process, and if the CIRP process fails, only then NCLT is going to order the liquidation process. Also check section 271 where the section has been amended and the ground on which the company could be wound up, there has been an amendment to that where the default part has been deleted. So this is one of the question which can be asked from the liquidation part. Thereafter, uh, without prejudice to the other provisions which are there, that can be asked, but I'm just going through the important provisions towards the last day. So you have this preferential transaction. So if any preferential transaction has taken place, this can be asked on this. Any question can be asked on this, that what is a preferential transaction and what is the relevant time. So preferential transaction means where the corporate debtor, okay, where the corporate debtor has given preference to any of its creditor, okay, and have provided them a preference, putting them into a beneficial position other than, you know, as compared to the position they would have been if the corporate debtor would have gone into liquidation and what they would have got. So if the company, so let's say I am the corporate debtor, okay, and you are the creditor. I have given you some preference, okay. Now, if I have paid you rupees 100 versus now if I would have not paid you this 100 rupees, okay, fraudulently, not fraudulently, I would say if I would have not given you this preference, then if the company would have got liquidated, you would have got only 80 rupees. In that case, I have put you in a beneficial position because I have given you preference. I have paid you 100 rupees. And if you would have not been paid this 100 rupees, you would have waited for the CRP process to end, then the liquidation process to start, and then the liquidation process to end, and you would have got only 80 rupees. So this 20 rupees benefit that I have provided you, this will make our transaction into the preferential transaction. So corporate debtor shall be deemed to have given preference if there is a transfer of property or interest of the corporate debtor for the benefit of the creditor or surety or for the guarantor on account of an antecedent financial debt, operational debt, or other liability owed by the corporate debtor, and this is important, and the transfer has the effect of putting the creditor or surety or a guarantor in a beneficial position than it would have been in the event of the distribution of the assets of the corporate debtor under section 53. In that case, it will be called as a preferential transaction. Now, if the liquidator comes across any such preferential transaction, such preferential transactions would be now declared as void. So for this, liquidator will file an application to the NCLT, and NCLT will again restore the transaction. Status quo would be maintained, and such a preference would be considered as void. So what is the time limit for this? So time limit for this is, for a related party, the time limit would be 2 years prior to the commencement of the insolvency process, and for other than related party, it will be 1 year. So when my CRP process started, if prior 2 years to that you are a related party, I had given you any preference, in that case it will be called. Before that, it doesn't matter, but if you're not a related party, then the relevant time period would be 1 year. So order for this, that's what I said, the property will have to be restored back to the company, okay, or the equivalent amount have to be paid to the corporate debtor back, and that transaction would be considered as void. Similarly, you have undervalued transactions. So what happens in case of undervalued transaction, where the corporate debtor, okay, where the corporate debtor makes a gift to a person or enters into a transaction which involves the transfer of one or more assets of the corporate debtor for a consideration of a value which is significantly less than the consideration to be provided by the corporate debtor. So in that case, this would be considered as a undervalued transaction, and similar effect would be there. The liquidator would go to NCLT and file an application for such undervalued transactions, that it has observed these undervalued transactions, and these undervalued transactions would be declared as void by NCLT, and whatever property has been transferred, the gift have been made, or whatever the property has been transferred would be restored back to the corporate debtor. So this is there. And if such liquidator does not file the application to the NCLT, or if it fails to come across or identify such undervalued transactions, the creditors may also report it to the NCLT. Okay, the creditors may report it to the NCLT that liquidator failed to identify such undervalued transactions or had taken no action even after being the knowledge of such undervalued transactions. So in that case, the liquidator would be removed. Okay. Then you have transactions defrauding the creditors. So what happens in case of transaction defrauding the creditors? The corporate debtor, okay, the corporate debtor deliberately keeps an attempt to keep the assets of the corporate debtor beyond the reach of any person, so that the claim cannot be made on such assets, or does anything which adversely affect the person, okay. In that case, NCLT is going to restore the possession what has existed before the transaction, that is the status quo is going to be maintained. It is going to protect the interest of the persons, okay, those who are the victim of such transactions. Then you have the extortionate credit transaction. Now, what do you mean by extortionate credit transactions? A high value credit transactions. So such high value credit transactions would be again considered as void. So what will be considered as an extortionate credit transaction? So if a credit transaction took place, it could be financial, it could be operational, during the last 2 years preceding the insolvency commencement date, and the liquidator come across or the resolution professional come across that these are extortionate credit transactions. Extortionate credit transactions means high value credit transactions, unusual credit transactions that have taken place, which requires exorbitant payments to be made. A very high amount of you know interest or the payments is to be made by the corporate debtor. In that case, NCLT, I mean the liquidator would go to the NCLT and file the application for such extortionate credit transactions, and again it is going to restore. So if you can just notice, in all these transactions NCLT is going to restore the possession, set aside whatever transactions was they made, okay, and it is going to be the duty of the liquidator or the resolution professional to file to the NCLT about such transactions. So till now they haven't asked about any question from these transactions, but we never know that you may get one such question in your attempt. So if you get it, do define what is that transaction. Thereafter you decide, you have to write that who is going to file the application for such transaction, and then what is going to be the order. So order is very common across all. What is the relevant time period? That is something which you really need to remember here. Thereafter, in this liquidation part, you can have this question regarding the waterfall provision. What is going to be the distribution process? So distribution process would be the from the liquidation assets or from the liquidation estate. First, the insolvency resolution process cost and the liquidation cost would be taken full. After that, the workman dues would be paid for the preceding 24 months and the debts which are owed by the secured creditor who have relinquished their security interest. So there was a secured creditor having fixed charge on the asset. So technically the secured creditor had the right to go and realize the amount from that particular asset. But instead of doing that, the creditor had relinquished the security interest and the liquidator was asked to realize the money. So in that case, the liquidator is going to pay to such secured creditor who has relinquished the security interest. After that, the payments would be made to the wages and the unpaid dues which are owed to the employees other than the workmen for a preceding 12 months to the liquidation commencement date. Then the amount would be paid to the financial debts which are owed to the unsecured creditors. Thereafter, the payments will be made to the central government, their dues, and the debts which are owed by the creditor for any amount unpaid following the enforcement of security interest. So just quickly, I'll tell you, I am a secured creditor, okay, having a fixed charge, and my dues was what? My dues was rupees 1000. After enforcing my security interest, I could realize 700 rupees. So the 300 rupees which I have not realized by selling that particular asset, that will be paid here. However, if I have relinquished the security interest, I said to the liquidator that I am not going to sell this asset. You only sell this asset and pay me the money. At that point of time, I am going to get entire 1000 here. If I enforce my security interest, then after selling the asset or realizing the asset, whatever amount I get, I'll keep it if satisfied. If it completes my dues, let's say the amount realized was 1200, then in that case, I'll not come here. But if there was any under realization after enforcing the security interest, then for that balance amount, I'll come here. After that, any other debts which are paid or which are payable, that will be paid. Then the amount will be paid to the preference shareholders along with their preference dividend in arrear. And if any amount is left, that would be paid to the equity shareholder or to the partners. So this is what is I feel is important for the liquidation of the corporate debtor pursuant to the resolution plan not getting approved or failure of any resolution plan. So that's it for this video. If you have heard this video till here, all the best for your exam and take care. Don't forget to like and subscribe to my channel and press the bell icon. Thank you. Take care. Bye bye. All the best.